Good afternoon and welcome to our Character in the Professions Conference. My name is Kenneth Townsend and I am Director of Leadership and Character in the Professional Schools and Scholar in Residence in the School of Law here at Wake Forest. For those who have participated in previous sessions, welcome back. And for those joining for the first time, welcome. We have had over 2,300 registrants from across the United States and 37 countries sign up for this conference. And along with the Oxford Character Project, we in the Program for Leadership and Character are delighted to have you for this, our final session. Thanks also to all of our conference partners and funders who have helped make this conference possible. Before we get started, I want to make a couple of notes. First, with the support of Wake Forest Program in Interpreting and Translation Studies, we are offering live interpretation of today's session in both Chinese and Spanish. So if you would like to access interpreting services, please click on the button at the bottom of your Zoom screen. Also, I want to highlight that this session has been approved by the North Carolina Bar for 2 hours of Ethics Professional Responsibility, CLE. If you want to receive CLE credit but haven't yet signed up, you can amend your registration and make the required payment on our registration page. Before introducing our featured speaker, I must first reference someone else. The Stanford Law School's Deborah Rohde agreed last May to be our featured speaker for this Character in Law session. She shared with me an almost final draft of her paper for the conference last December. It was entitled Character in Law, the Bar's Misplaced Focus and Why It Matters. Sadly, just a few days after sharing this almost final draft, Professor Rohde passed away unexpectedly. Her passing has been felt by so many, and we want to remember and honor her with today's program. Professor Rohde's colleagues have been so helpful in helping us navigate the loss and trying to find a proper replacement, which is very difficult given the shoes that she has left to fill. But it is my distinct honor to introduce to you one of her colleagues and partners, Professor Debbie Muckamal. Debbie is the Executive Director of the Stanford Criminal Justice Center at Stanford Law School. She has co-directed Renewing Communities, a statewide initiative to expand college opportunities for incarcerated and formerly incarcerated students in California, led the center's efforts to address the admission bars to law school and the state bar for people with criminal records, and co-founded and run Project Remade, an entrepreneurship boot camp for people with criminal records. Professor Muckamal's presentation today will touch on and amplify portions of Professor Rohde's paper, Character in Law, while also drawing upon some of her recent work in California, including a report she co-authored entitled Unlocking the Bar, a report that, among other things, calls upon the legal profession to think more broadly about the role of character in the practice of law. This afternoon, following Professor Muckamal's presentation, we will have time for questions from the audience. The chat function is disabled, so please use the Q&A function at the bottom of your screen to ask questions. My colleagues and I will field these questions and present them directly to Professor Muckamal. We will not, however, have audience Q&A following the later panel discussion, but we do hope that you will stay with us for this really engaging panel discussion that features a range of all-stars and will be moderated by our Dean, Jane Aiken of the Wake Forest School of Law. So without anything further, welcome, Professor Muckamal. We are grateful to hear from you today. And are you on the screen? Go ahead and click there we go. Welcome so much. Thank you so much, especially under the circumstances. We're so grateful to have you with us today and are excited to hear what you have to share with us. Welcome.
Thank you so much for inviting me. And thank you especially to Kenneth and the other conference organizers for your superb organization. Most of you are probably here because you thought my very esteemed colleague, Deborah Rohde, was giving this address. I wish she was too. Although tiny in physical stature, Professor Rohde was a giant in the legal profession, doing more through her academic scholarship to advance justice, access to justice, moral character, and gender issues than any law professor ever has. I can't replace Deborah, but I hope my remarks pay due respect to her unmatched and revered legacy. What I hope to do this afternoon is to elevate a few of the themes that Deborah explored in her brilliant essay on the role of character in the legal profession. If you haven't already done so, I encourage you to read her paper. I'll be talking about what our center undertook to better understand whether and how qualified people with criminal records have access to the California State Bar. This was research and advocacy that built directly off and was influenced by Deborah Rohde's decades-long scholarship on moral character. I plan to leave ample time at the end and hope we can engage in robust discussion in memory of Professor Rohde. I'll be focusing on California, though the themes we uncovered are not unique to the Golden State. We had access to California State Bar officials and California law school officials that made undertaking the research easier. Also, the work grew from adjacent work we were doing to expand college opportunities for currently and formerly incarcerated students in California. Professor Rohde asserts in her paper that the legal profession cares deeply about character. Indeed, every state requires that new applicants to the legal profession demonstrate good moral character. The American Bar Association's model rules of professional conduct maintain that as an officer of the legal system, each lawyer has a duty to uphold the legal process, to demonstrate respect for the legal system, and to further the public's confidence in the rule of law and justice system. Despite this supposed focus, Professor Rohde identifies myriad ways the bar has fallen short in achieving the aspirations laid out by the model rules. As she states, the profession has done too little to reinforce models of exemplary character as the guide for daily practice. The bar can and must do better, and society has a substantial stake in demanding it. No occupation provides such a high percentage of America's leaders. To be sure, the stakes are high. The legal profession is essential to a functioning democracy, and the public benefits when people are qualified for and committed to entering the legal profession have a fair chance to serve as lawyers. In the first part of her essay, Deborah discusses the bar's century-long history of using moral character requirements to gatekeep the profession. Moral character screening has sordid origins. Its rise was motivated in part by nativist, ethnic, and anti-Semitic biases, and it has been used as a means of restricting the admission of Black, Jewish, and immigrant applicants. The standards for disqualification in the early 20th century were decidedly vague, and at least one county board in 1929 was rejecting candidates based on such qualities as being subnormal, unprepossessing, shifty, smooth, keen, shrewd, arrogant, or surly. Examiners claimed that they could discern from interviews whether candidates lacked moral stamina or a proper sense of right and wrong. And as late as the mid-1980s, the moral character requirement was being used by some state bar examiners to deny admission based on applicants' peaceful protest activities and sexual orientations. While moral character standards for both admission and disciplinary stages have become common, they were and are inconsistently applied and haphazard. In some jurisdictions, seemingly minor or unrelated past conduct have made an applicant ineligible, whereas more serious and related past conduct was not disqualifying in other jurisdictions. Such inconsistencies might be understandable. In fact, the Supreme Court has described character requirements as unusually ambiguous and has avoided specifying what constitutes good moral character, requiring instead and merely that there be a rational connection standard between the character criteria and the applicant's fitness or capacity to practice law. Despite all requiring that their applicants possess good moral character, most states define it vaguely. And in fact, many states use the term without actually defining its meaning. Oklahoma, for example, simply states that the applicant shall have good moral character, due respect for the law, and fitness to practice law. 9 other states have similarly opaque standards. In the states that have defined moral character, the definition is often a list of character traits that provides insufficient guidance to the applicant. California's definition includes a non-exhaustive list of character traits. Good moral character includes, but is not limited to, qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others and the judicial process. This broad, non-specific definition mirrors that of many other states. Professor Rohde points to the inherent difficulty the bar, like other licensing authorities, has in determining the relationship between past conduct with predictions of future misconduct. As she says, moral conduct reflects a complex interrelationship between traits and situations, and contextual norms, incentives, and pressures have a substantial impact on ethical conduct. Knowing that someone engaged in unethical conduct in the past is insufficient to predicting that they will do so again. The bar would also need to know why the person engaged in the behavior, but that is really hard to do. Today, the moral character review process for bar admission involves screening applicants for a range of past behaviors, including their criminal records. In doing so, and without intention, the moral character review process will likely reflect the racial disparities that plague the US criminal justice system as a whole. In California, for instance, whites comprise more than a third of the state population, but only a quarter of the prison population. More notably, Blacks make up almost 30% of the prison population, but only 6.5% of the state population. Moral character screening that involves criminal record review is likely to perpetuate the underrepresentation of people of color in an already exceptionally non-diverse profession, at precisely the same time that the legal bar has amplified efforts to diversify the profession and address structural racism. Moreover, given current societal conditions, admissions policies that consider an applicant's criminal record are likely to affect a significant number of people. Massive numbers of individuals in the United States have criminal records today. Over 70 million individuals, or over 1/5 of the US population. In addition, growing number of incarcerated and formerly incarcerated people now have access to college opportunities and will have the educational qualifications to pursue legal professions. As a result, more qualified candidates than ever before may be prevented from realizing legal careers by admission policies that screen based on criminal records. Indeed, more than any other state in the nation, California's public higher education system is now reaching men and women who have been adversely impacted by mass incarceration, whether they are in prison, jail, or on our college campuses. As of 2018, 34 out of 30 of California's 35 state prisons offer face-to-face, full credit, degree building college courses. More than 5,000 students are enrolled in these face-to-face college pathways each semester, or about the same size as MIT's undergraduate class. And they have consistently outperformed students on campus. In addition, 1/3 of California's college campuses and more than half of its 23 California State University campuses now have a formal or informal support program for formerly incarcerated students, with that number continuing to grow. While protection of the public is the primary justification for screening applicants for their criminal records, evidence suggests that doing so at the time of bar admission is not a good predictor of subsequent misconduct, and when used may be ineffective and overly broad, undermining the goals of the screening itself. As Professor Rohde noted in her essay, a Connecticut study from 2002 reviewed 1,300 bar applicants and their subsequent disciplinary records, but couldn't identify any factors at the admission stage that could have predicted the subsequent misconduct. Desistance studies also show that there is a certain period of time after which an individual who commits a crime will be no more likely to commit another crime than someone who had never committed a crime in her life. Moreover, a growing body of empirical and survey research demonstrates that in the workplace, individuals with a criminal record perform equally to or better than their counterparts with no criminal records. There is a phenomenon of people with criminal records desiring to give back and seek professional avenues like human services, social work, and the law as a means of using their own personal experiences to advocate on behalf of others. A number of federal and state laws reflect this body of research by limiting how colleges, employers, and other decision makers may consider applicants' criminal records. These regulations, sometimes referred to as ban the box policies, usually require that there be a nexus between the job being sought and the criminal record. They throw out old convictions and forbid the use of arrests that didn't lead to conviction in decision making. What is at stake when we screen in ways that are arbitrary, discriminatory, or empirically ill-grounded? Who do we risk losing to contribute to the legal profession? Let me share some prominent examples of formerly incarcerated individuals who went on to become successful lawyers. Tara Simmons spent years in prison and jail as a result of convictions stemming from her addiction. After her release and after receiving treatment for her addiction and trauma, she graduated from law school, but was denied the ability to sit for the Washington State Bar after the bar's Character and Fitness Board found her to lack moral character. She took her case to the Washington Supreme Court, and in a unanimous opinion, the court reversed the board's decision. She was awarded a Skadden Fellowship, practiced law at the Public Defender Association in Seattle, and in this last November, she was elected to the Washington State Legislature, where she now serves on the Civil Rights and Judiciary, Healthcare and Wellness, Public Safety, and Rules Committees, being the first formerly incarcerated person in the state's history to do so. Sean Hopwood is a second conspicuous example. He spent years in federal prison for several bank robberies, but after release went on to become a member of the Washington State Bar and then a professor at Georgetown Law School. He now draws on his experiences to advance reforms to the criminal justice system through appellate representation and research scholarship. Frankie Guzman is a third. He was sentenced to California's prison for youth multiple times, including for stealing a car and robbing a liquor store, before he went on to graduate from UCLA School of Law and to join the California State Bar. In 2012, he was awarded a Soros Justice Fellowship to join the National Center for Youth Law. He has remained there since as an attorney, advocating on behalf of at-risk youth and for reform to the juvenile justice system he had experienced firsthand as a teenager. Recently, his leadership contributed both to the establishment of the California System-Involved Bar Association and a state law that prevents young people from being charged as adults in the California criminal justice system. Each of these examples demonstrate the unique value formerly incarcerated people can bring to the legal profession. From 2015 to 2020, we co-led statewide work to expand access to college opportunities for incarcerated and formerly incarcerated people in California. We found that as the educational achievements of these new college students grew, their professional aspirations did too. They sought more than a job, they wanted careers. And as I stated earlier, they were attracted by professions that enabled them to help others, to give back. Ironically, it is these same professions where their criminal records would create legal barriers. So as an extension of our work on opening access to college opportunities, we wanted to better understand the extent to which people with criminal records are blocked from the legal profession. In that vein, we undertook original research and made several significant findings. And I should say as a sidebar that the research I'm going to speak about was undertaken as a policy lab at Stanford with students working alongside me and my colleagues at the Stanford Criminal Justice Center and at Deborah Rohde's Center on the Legal Profession. I'm happy to talk more about that, about how those policy labs work, if that's of interest. So anyway, here's what we found. We found that there are successive barriers that exist to keep people with criminal records from joining the legal profession, and that it is not just the state bar that gatekeeps, but that those barriers come much earlier. I apologize that I keep doing this share screen, but I wanted to show a few slides. Okay, Here we go. So first, individuals with criminal records are deterred from applying to law school in the first place. We surveyed 88 individuals with criminal records across the United States, all who identify themselves as criminal justice leaders. Over half cited the concern of passing the moral character requirement as one of the top 3 reasons for why they had not yet applied for law school. As one admitted in our survey, "I thought because I had a felony, there was no chance, so I never tried." Law schools serve as the first formal gatekeepers. We talked with deans of admission from 10 ABA accredited California law schools, representing a range of tiers and both public and private law schools. We also reviewed the disclosure requirements for 20 ABA accredited California law schools, again at a range of tiers and both public and private schools. And we spoke to a number of student services deans at a number of law schools as well. Among the admissions deans, most, 7 out of 10, said that their school considered the California State Bar's moral character requirement when crafting their own disclosure requirements. And 8 in 10 consider whether an applicant would pass the State Bar's moral character component when making admissions decisions. ABA Standard 501B requires that law school admissions officers deny applicants who do not appear capable of being admitted to the bar. And several of our admissions deans referenced that standard as one of the reasons for their policies. As one officer explained to us, one of the primary functions of the law school is to prepare individuals to be members of the bar. So to ignore moral character misses the point of what a law school is supposed to do. Another admissions officer shared that her law school asked for applicants' criminal histories because we have a moral duty to help our students get through the bar so that they don't waste 3 or 4 years and $180,000. We would not consider admitting first and then asking later. In addition to the moral character requirement, admissions officers pointed to safety, liability concerns, and a desire to assess applicants' judgment for their reasons for requiring criminal record disclosures. Applicants must answer different questions about their criminal records for each different law school they apply to, making it difficult for the applicant to craft a single statement that explains their criminal record. For example, half of the law schools we spoke to and looked at require applicants to disclose past arrests, even if those arrests did not lead to charges, and the other half do not. Similarly, while 3 of the 20 law schools explicitly do not require applicants to disclose expunged convictions, about 1/3 of the law schools do, and the rest are unclear about whether expunged convictions must be disclosed or not. As a result, an applicant may be in the position of disclosing different information about her criminal record, depending on the particular requirements of each school to which she's applying. Moreover, in many cases, it's not clear what criminal record information a particular law school requires the applicant to disclose. For example, in our analysis of the 20 ABA accredited California law schools moral character disclosure questions, we were unable to determine for at least half of the schools whether they wanted applicants to disclose juvenile offenses, sealed offenses, or dismissed offenses. Also, the criminal record information that law school asks applicants to disclose differs from the criminal record information that the California State Bar asks applicants to disclose. In many cases, law schools ask applicants for more information than the bar asks for, even though the admissions deans indicated that one of the reasons for asking the questions is because of what the State Bar asks. In many cases, law schools ask applicants, as I said, for more information. Finally, admissions officers lack access to information and training relevant to making informed moral character determinations. Admissions officers estimated that as low as 1% and as high as 25% of the applicant pool to their respective schools disclose criminal record issues each year. The most common disclosures are substance-related offenses like drug possession, driving under the influence, and public intoxication. And half of the admissions officers we interviewed stated that they had no policy for reviewing applications with criminal record disclosure and no single expert they can turn to understand the relevance of an applicant's criminal record. Most will follow up with applicants from whom they need more information or context to reach a decision, but only 2 indicated that they requested court documents, and even these 2 do so very rarely. None conducts a criminal background check, and none offers in-person interviews to applicants with conduct issues. Indeed, at least 2 admissions officers stated that they consider it a negative to need to follow up with applicants for more information. Once matriculated to law school, law students with criminal records continue to face barriers that block their access to the legal profession. Law schools differ in terms of the level of communication that takes place between admissions officers and student services officers regarding admitted students with criminal records. Student services officers with more information reported being better able to proactively engage and aid those students who may need individual assistance. We also found that most law schools discuss the state bar's moral character requirements with law students at some point during the student's first year of school. But there's considerable variety in how student services counsel students about and assist with their applications. Some are very hands-on, meeting with those who have potential moral character issues during their first year, whereas other schools leave it to the students to find assistance with attorneys who specialize in representing applicants with moral character screening, representation which can cost upwards of $15,000. Finally, certain unique issues arise for law students with criminal records in addition to those posed by applying for state bar admission. In particular, students with criminal records encounter unique challenges in seeking employment, and they may experience learning about and discussing criminal law topics differently than do their peers with less direct exposure and experience with the criminal justice system. For instance, one student told us that he wasn't sure when and how to disclose his criminal record to a summer employer who had made a post-graduation offer to him. He said that the career services staff at his law school didn't know how to advise him either. The state bar's moral character review process serves as the final gatekeeper. When we examined the California State Bar's moral character review process, we found a number of barriers. For instance, the California State Bar asks applicants and their law schools different questions about the applicant's backgrounds. The State Bar asks law schools, but not law students, to provide them with records related to students' arrests, even if the arrest did not lead to a conviction. And the State Bar asks law students about their expunged convictions, but doesn't ask law schools to report that information about their students. Second, some of the criminal record information that the California State Bar asked was legally imprecise. For instance, the bar asked law schools whether a student was charged informally with a violation of the law, even though informal charge is a legally meaningless category. While a criminal record does not categorically preclude an applicant from being admitted to the California State Bar, applicants who have been convicted of violent felonies, felonies involving moral turpitude, and crimes involving a breach of fiduciary duty were presumed not to be of good moral character in the absence of a pardon or showing of overwhelming reform and rehabilitation. These terms also carry imposition. Violent is a moral and descriptive term, not by itself a formal legal term or category. Moreover, where the term violent felony appears in federal and state statutes, it can have widely variant criteria depending on the legal context. The same is true for crimes of moral turpitude. Not only does this vagueness lead to confusion for applicants, it may also lead to inconsistent decisions by the State Bar. A few states' rules explicitly specify that certain types of criminal history will either be an absolute bar to admission or may constitute grounds for recommending denial. In Mississippi, for example, felonies and certain other convictions are an absolute bar to the practice of law. Alabama prevents an applicant from admission unless she has received a full pardon for her crime and the full restoration of her civil rights. Georgia requires applicants to have received one or the other. In Idaho, a conviction of a serious crime constitutes criteria for disqualification of an applicant on character and fitness grounds, and serious crime is defined as any felony as well as any lesser crime that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. Similarly, In New Hampshire, criminal acts, whether or not the conduct results in a prosecution and conviction, and even though the arrest and/or conviction for the conduct may have been annulled, may be grounds for the committee to recommend denial of admission for lack of character and fitness. In many states, a criminal history that includes certain kinds of crimes will create a rebuttable presumption that the applicant lacks good moral character. California had such a rebuttable presumption for certain kinds of crimes, as I mentioned earlier, until very recently. The California State Bar, like most state bars, places great value on applicants' candor. Various stakeholders we spoke to raised concerns about quote unquote candor traps into which applicants can and sometimes do fall. The potential exists for applicants to inadvertently fail to disclose required information about their criminal history, and this inadvertent disclosure may be perceived by state bar officials as an intentional omission indicative of the applicant's lack of candor. Candor traps are common for a number of reasons. Rap sheets are routinely inaccurate. Students are misinformed by attorneys that their records are clean when they are not, and the records reported to the state bar are often different from the ones the subject of the record can review. The composition of the decision-making body is also a factor. In California, there are no requirements that any members of the committee that determines whether or not an applicant has good moral character has special training or expertise in substance abuse, mental health, financial management, or any other substantive area of value to the committee. This differs from other states. In Wyoming, for instance, the committee is comprised of 4 members, one of whom is a non-lawyer with special training in substance abuse, mental health, financial management, and other subject expertise. Finally, the state bar's data collection and transparency policies reinforces a lack of access. The bar seals its admissions decisions and does not collect or share data on moral character determinations. It does not publicly provide on its website or otherwise examples of the kinds of criminal convictions they see among applicants that have and have not been granted admission. And until recently, it didn't provide concrete examples of the quantity and character of evidence that successful applicants produce to prove their rehabilitation. As a result, prospective law students and lawyers, law school student services officers, and other relevant actors lack access to useful information about the moral character review process. Finally, and as Deborah Rohde noted in her paper about many other states, California's processes and standards for attorney discipline differ from its processes and standards for attorney admission. A number of differences stand out, including those between the standards of evidence and burdens of proof imposed on each process, the types of activity that engender scrutiny, the possible consequences of an adverse finding. The question remains, are we spending more time erecting barriers to the profession when we should be expending resources to ensure the profession upholds its character ideals? How might we reverse the direction of this pipeline and expand access to qualified people with criminal records? And how would such strategies benefit other disenfranchised groups the bar might be trying to attract? Let me offer a few quick recommendations. One is to create a law school admissions pipeline where we might conduct greater outreach to formerly incarcerated students and those with criminal records to share information about law school and state bar admissions processes and dispel myths about how criminal records affect admission. The growing number of college support programs for formerly incarcerated students could serve as an ideal venue for such outreach. We could also collect and disseminate profiles of successful lawyers who were incarcerated prior to seeking bar admission. To mitigate the deterrent effect, we need to elevate the success of others, demonstrating that it is not only possible to overcome the moral character screening, but that the profession welcomes them and their unique expertise. We need to reform law school admission policies and practices. We should provide professional development on desistance, implicit bias, and other relevant research to law school admission staff and others making admissions decisions, and institute admission policies for applicants with criminal records that are evidence-based and applied consistently across applicants. We might consider standardizing criminal history disclosure questions and requirements on law school applications so that applicants can prepare a single but comprehensive statement about their criminal history. We should think about targeting student services to support law students with criminal records once they're in law school. We should develop best practices to ensure that students who are formerly incarcerated or have criminal records are adequately supported while they're enrolled, including informing them about the moral character review process early in their studies so that they have adequate time to compile a strong application, and providing individual counseling to these students on how and when to disclose their criminal records to potential employers and on how to navigate state bar moral character processes. We might also provide professional development to faculty and staff to ensure that they are equipped to sensitively and more effectively respond to the particular needs of students with criminal records in the classroom and in the law school community. We might also connect advocates to assist formerly incarcerated students applying for state bar admission. We might develop networks to connect state bar applicants who have criminal records to pro bono lawyers who can assist them in their applications, and develop training to pro bono attorneys willing to assist these applicants with their moral character screening. And finally, what might we do with the state bar admissions policies and practices themselves? We might think about eliminating certain kinds of records from the review process. We want to make sure that the state bar's moral character decisions are grounded in and driven by relevant research, and mitigate any discriminatory effects the moral character review process may have, including by requiring that at least some members of the committee have a background in psychology, substance abuse, mental health, or other areas of value, and providing professional development to the state bar staff and committee members that includes training on desistance and other relevant topics. We might also require that the state bar enhance the clarity, transparency, and accessibility of the state bar's moral character standards and processes, including by ensuring that the state bar provides more and clear guidance that is comprehensible to lawyers and non-lawyers alike, and that they collect and disseminate yearly statistics on applicants with criminal records and their admission rates. Such information would help applicants, but also law schools who are preparing students for bar admission. Sometimes one's research is perfectly timed. Ours was. In 2019, as we were finishing up this research, the State Bar convened a working group to elevate the standards applied to moral character determinations. The goal of the work group was to review existing processes and to develop clear and appropriate guidelines for determining whether an applicant possesses the requisite moral character. As my invitation to the working group indicated, the bar hoped that the group would create policies and processes that ensure greater uniformity and consistency in decision-making, provide transparency into the moral character evaluation process, and ensure the State Bar provides appropriate consideration for rehabilitative efforts undertaken by applicants. As you can imagine, I was keen to join this group. The work group included 7 members, 3 members of the Committee of Bar Examiners, and 3 deans of California-based law schools. I was the 7th member. The task force convened for 9 months, and I'm proud to say that all before COVID hit, and just before COVID hit, because our last meeting was in February of last year, we made and had approved by the Committee of Bar Examiners, the State Bar Board of Trustees, and the California Supreme Court, all of which are required review when you're making any kind of policy changes at the State Bar. And here's what we accomplished. We updated the moral character statement to elevate the values of transparency and emphasize the consideration of rehabilitation. The statement now reads, the process for making a moral character determination for those seeking admission to the State Bar of California and a license to practice law shall be uniform, consistent with governing law, and transparent. The process shall adhere to best practices and ensure that appropriate consideration is given to rehabilitative efforts undertaken by applicants. Perhaps most importantly, what the working group did is to develop transparent guidelines that the State Bar could use and make available to applicants. The guidelines are characterized by 4 sets of character traits set out in the governing law. So that is respect for and obedience to a law, which pertains to felony and misdemeanor convictions, juvenile records, and vehicle code infractions. Honesty, candor, trustworthiness, fairness, which would include honor code violations, job terminations, omission of information, fraudulent activity. Third, observance of fiduciary and financial responsibilities, including issues like bankruptcy, past due debt, and unpaid income taxes. And fourth, respect for the rights of others and judicial process. So that would cover instances of malpractice, professional discipline, court sanctions, malpractice, military discipline, and civil actions. For each category, the matrix identifies the level of review that would likely be required and the types of mitigating or aggravating factors that will be considered. So for instance, for a nonviolent conviction that is more than 5 years old, it's not likely to require additional inquiry, but a violent one will. And the matrix guides the applicant as to what evidence the bar will weigh heavily in determining the relevance of the misconduct. So for a criminal record, the age of the person when the misconduct occurred, the social factors that might have contributed to the misconduct, and rehabilitation directly tied to the misconduct are among the factors the state bar says are probative. This specific information for each type of potential misconduct is something that the state bar never had before, and which is now incredibly welcome by both applicants and by law school admissions directors who were trying to get more specific information about what the state bar will consider for applicants. And then the other two things that the working group did was to eliminate discrepancies between what the bar was asking of law students and what it was asking law schools about those law students, so that that information is now in alignment. And it eliminated the presumption of ineligibility standard that once existed for violent felonies and felonies involving moral turpitude. The standard now reads, there is no criminal act that disqualifies an applicant from receiving a positive moral character determination, given a sufficient showing of rehabilitation. Where serious misconduct occurs, positive inferences about the applicant's moral character are more difficult to draw, and negative character inferences are stronger. When there have been serious acts of moral turpitude, the applicant must demonstrate that he or she behaved in an exemplary fashion over a meaningful period of time. Criminal acts not involving moral turpitude, such as some acts of civil disobedience, do not provide a basis for a negative moral character determination, absent evidence beyond the act's criminal nature that shows it demonstrates a lack of good moral character. Shifting the presumption signals to formerly incarcerated applicants that their aspirations don't need to be uniquely tied to their criminal records. All of these changes were made in tandem with a new process that emphasizes staff decision-making over the committee of bar examiners members making those decisions, thereby making the consistency of decision-making more probable. I want to think that Deborah Rohde would approve of all the changes that we made. Finally, Professor Rohde urges all members of the bar to elevate qualities of character and service of the profession in our democracy. She says the profession needs to do more to help lawyers develop and nurture qualities of character, as well as the support structures necessary to sustain them. Our system of justice and democratic institutions depend on it. It is unquestionably legitimate and important to protect the public from the risk of lawyers who, even if intellectually qualified, may disserve their clients and the legal system through fraudulent or deceptive conduct. As we law school administrators, mentors to law students and young graduates, attorneys at large and small law firms, legislators and policymakers manifest this mandate, may our commitment to uphold our profession's moral character be steadfast, but also narrowly tailored so that we can simultaneously pursue equally important societal goals, like encouraging rehabilitation and successful reentry, recognizing redemption when it occurs, promoting diversity, and addressing structural racism. I look forward to your questions.
Thank you so much, Professor Muckamal. This is really interesting, and it's so impressive, all of what you have done, and to see the tangible results, I know has to be pretty neat. So we do have some questions that have started to come in, and you do have a Q&A box down there at the bottom of your screen. Feel free to add in your questions for Debbie. But before we get started on that, one thing that strikes me as I listened to your presentation concerned the various dimensions of character, including character of the institutions that train lawyers, the character of individual lawyers and lawyers to be, as well as the character of the legal profession itself. So what I heard you say in so much of your work on this report, it seems to reflect a commitment to virtues of justice, fairness, and mercy when determining who is eligible to join the profession. But as we move forward in this conversation, it might be helpful for us to think about these different dimensions of character, both individual questions of character as well as institutional and professional questions of character. Not so much a question, but a framing to keep in mind as we move forward. So our first question is as follows. How do you think that legal education and or the legal profession can best promote the particular virtues that are needed for lawyers to practice and lead with integrity without falling prey to the limitations associated with some of the moral character requirements that have been so unfairly applied in the past?
Yeah, that's a great question. And I would refer everybody to Deborah's article, because I think she addresses that head on in her essay, both in terms of thinking about how we gatekeep at the front end and where we put our resources. Deborah was one who thought very passionately that we put more resources keeping people out and not enough resources making sure that the bad apples are not kicked out, as she liked to say. So I think that, but I think in Deborah's essay, and she's thought a lot more about this than I have, I mean, she speaks really passionately about what we need to be doing to call out when our fellow attorneys and members of the bar are not living up to the character standard that we really are supposed to uphold, and that we shouldn't shy away from that sort of calling out. And then I think the third part of her essay is really about what are the kinds of efforts that we can be making to make sure that, particularly, and I know in the next panel you have a lot of fabulous deans who are going to be speaking, where do we cultivate that in professional school so that those attributes get ingrained in our young graduates and sustain them in their professional careers. So I guess in answering your question, I would refer people to the paper, and Kenneth, I'm assuming it's on your website, or we can make it available somehow.
Yeah, we will be making it available. It is not quite in a final form. We're making some final
Great.
to it, but it will be available. And our expectation is, I don't have an exact timeline for this, but for those wondering, our hope is, and expectation is, to produce an edited volume that will include each of the presentations that were made for this conference, including Deborah Rohde's posthumously as part of that volume. But we'll have a draft version of that available. We just want to make sure that whatever goes out in a broader way is cleared with various folks at Stanford, including some people who she had worked with. So our next question is from Rich, who asks, do you think that nonviolent convictions are less problematic than violent convictions? I serve on my state bar's grievance committee. We have a steady stream of lawyers being disciplined that have substance abuse problems, bar applicants that have a criminal history involving drug abuse or theft-related offenses related to funding a drug addiction should raise many red flags, especially for attorney misconduct related to theft of client funds. I do not see the same problem with bar applicants having violent convictions that do not indicate an addiction.
It's such a great question, and I would refer Rich to our paper, because there's a really great discussion of the desistance literature. We summarize the desistance literature, and as it looks at, the likelihood of someone depending on the type of crime that they've been convicted of, whether or not that be like a robbery versus a nonviolent offense versus something else, what's the likelihood of that happening again? I'd also just call out that for individuals who've been convicted of violent offenses, they've likely already spent a lot of time in prison. They've likely, quote unquote, aged out of crime. And thirdly, they've already undergone likely some kind of review process from a parole board that has dealt with some of the character issues that a character and fitness committee would also be looking at. They're looking at things like insight. Does the individual have insight to what their role was in the crime that was convicted? How do they think about that? And so that's already happened. And so by the time that individual with a violent criminal record comes to the character and fitness bar, they've already gone through, there's been a lot of time that has passed. There's been, it could be upwards of 20 years since the conviction happened. And so some of those red flags that you might be thinking about with someone who's had a substance abuse addiction aren't there. Many of the state bars also require, some level of, for those who have substance abuse addictions to go through some level of treatment. They sometimes provide provisional, provisional review, requiring that the person go through treatment before they, are deemed to have to be finally approved by the character committee. But I would really encourage you to look at our paper, Unlocking the Bar, because it does have a nice section on desistance.
And that I will be putting in the chat momentarily. That is final and can be read. You can Google it, but I'll put it in the chat shortly.
Thank you.
The next question we have is from Patricia Murphy, who asks if you can comment on the sufficiency of the requirement of good moral character as opposed to determining that one is not of poor moral character. So I'm not sure if you want to take this from just a practical, what does California say about this, or a more theoretical answer. Is it more important for lawyers to have good moral character or just not have bad moral character?
Yeah, I would say that at least from my examination of California, that I think they're more looking for that you don't have bad moral character. They're not looking necessarily that you have good moral character. So they're not necessarily elevating attributes that they're looking to see what misconduct you have in your background. So that's why they're looking at, like, what's your bankruptcy record? Where's your failure to pay income taxes? What's your past criminal record? They're not asking you to present like positive rehabilitation. They are sometimes asking for positive rehabilitation. For people with criminal records, we used to jokingly say to the state bar, it looks like you're asking for Mother Teresa, because you ask that, you indicate that, like, community service is not enough, because we as lawyers are expected to do community service. And so you really need to go above and beyond what's actually just required by any law student or by any attorney. So I would think that they're more looking for that. And that might be a shift that we might be able to do that is really more about being aspirational than about sort of correcting bad misconduct. It's a great question. And something really interesting to chew on. And I would think that maybe the next panel probably has a lot to say about that. Yeah,
and thanks also for fielding some questions that might be more roadie oriented questions. So thanks.
It's okay. I'm
you're
really
doing a
happy
great
to
job.
say when I don't know what I don't know.
No, you're doing a great job. I think this is another question that is somewhat roadie oriented, but I think can be answered relatively easily by you as well. And it reads as, Professor Rohde has indicated that the bar has done little to elevate exemplary legal leaders. Who do you think are exemplary lawyers that could provide relevant examples for us today?
Oh, wow. Well, okay, so I work in the criminal justice space, so it maybe seems it's a more narrow part of the legal profession, but I look at someone like Brian Stevenson, who heads the Equal Justice Initiative in Alabama, as as someone to hold up as a hero, who's used his legal training to not only address you know problems in the criminal justice system, but also used his legal training to mentor, really take a responsibility for mentoring young people and young lawyers and law students, but also to provide public education. So if you haven't been to Montgomery to see the Legacy Museum that the Equal Justice Initiative started, that to me is like an example of kind of using those law skills in also in a public education context that's really sort of exemplary. That's just one. I bet you have a bunch of examples, Kenneth, that you would offer.
And I bet our panel to follow will also consider perhaps this question. Brian Stevenson is a role model to so many. I think that is a fantastic example.
He was he was the very first person I heard speak when I was in law school.
Oh, right.
Like 30 years ago. So yeah.
My wife just finished reading Just Mercy, and actually it was involved in a conversation between the Program for Leadership and Character and the Oxford Character Project. So Just Mercy has been on some of our radars just in the last.
Oh, that's great. Yeah.
So we only have a few minutes left. And this is another Rhodey-oriented question that, to some extent, I think you can maybe weigh in on, but, maybe channel Deborah in so doing. Throughout her career, Professor Rhodey argued that lawyers are in some ways morally responsible for the work that they do and the clients that they represent. But this doesn't square perfectly with the so-called neutral partisan theory of lawyering that prioritizes a lawyer's duty to represent clients with zeal. Do you have any advice for how lawyers can seek integration between their values and their work while also taking seriously our duties to clients, including those clients whose values we don't always embrace?
Oh, what a great question, isn't it? Professor Rhodey talks about that in some detail in her essay as well, if I remember, Kenneth. And I don't know that I have anything brilliant to add to that. Because I think it is, those things can feel like they're in opposition to one another, but I don't think that they have to be. I think that what Deborah suggests is that there's ways to be able to do both, and that at some point there is a place where you do actually have to speak up, or you have to say, no, I won't do this, because it goes beyond sort of being the neutral partisan advocate that you signed up to be, and that probably where that place is different for everybody. But that nevertheless, we should be speaking about that there is a boundary for which we should not go beyond, even if that is different for everybody.
I think that's well put. And that's one of the things I tell my students is I'm not going to tell you exactly where to draw that line, but asking questions about the relationship and where lines can be drawn can be a first important step. So we're almost out of time. So I'm going to ask one last question. Sure. You referenced towards the end of your talk support structures. The term support structures for supporting character came up. So what support structures do you think are necessary to sustain the character traits that lawyers need to be good and ethical lawyers?
Yeah. That is a great question. And I haven't really thought about that necessarily generally for the profession. I think there's probably there's lots of places where that can come in. I think of CLE as a really potential opportunity that could be utilized in a much more fruitful way. As an example, like I think sitting in on something is not, and passively receiving information is really different than engaging with other people. And so I think that there's probably lots of ways in which, particularly after an individual's been admitted to practice law, that there are ways that we are checking in and making sure that those attributes are being upheld. Again, a great question for your next panel.
Wonderful. Well, thank you so much, Professor Mukamal. As we prepare to wrap up, I'm not going to say bye just yet. I'm going to give you one last chance if you'd like. If there's anything else that you would like to say, any final concluding thoughts you'd like to share before we do take a short break and then move into our panel. You're not obligated, but any final thoughts you'd like to share with our group?
I just want to thank you again, and I want to encourage everybody to read Deborah's essay because it's quite brilliant. And as one of the last pieces of her scholarship, I think it's really it's a beautiful testament to her body of work.
Great. Thank you so much. We're really grateful for you being with us today. Thanks for the work that you've done in California to make the legal profession more accessible. We're looking forward to the conversation continuing with our panel in just a few minutes. So thank you, Professor Mukamal, for being here and filling in for your colleague, Professor Rohde. So now, just to give you all a heads up, we're just past 4. We're going to take a very short break. So in about 14 minutes, we're going to be back on this same link. You don't need to go anywhere. If you do need to go somewhere, just go back to your email and click on the link that got you here to begin with. But feel free just to step away. We'll be right back. And when we do, we'll have Dean Jane Aiken from Wake Forest University School of Law, who will be moderating a real all-star panel. And so you don't want to miss this. This is the final session of our Character and the Professions Conference, and I hope to see you in just a few minutes. Thanks for being with us, and see you shortly. Welcome, or welcome back, whatever the case might be. We're so glad to have you with us for this last part of our conference, Character in the Professions. Thanks again to Professor Debbie Mukamal for the engaging presentation that many of us just heard. I am now pleased to introduce my friend, colleague, and boss, Jane Aiken, who is Dean of the Wake Forest University School of Law, and she will be moderating our panel discussion on character in the law. A reminder, there will not be audience Q&A following this panel discussion. Jane Aiken is Dean and Professor of Law at Wake Forest University School of Law. Prior to Wake Forest, she served in a variety of administrative roles at Georgetown Law, including Vice Dean, Associate Dean for Academic Affairs, and Associate Dean for Experiential Education and Public Service. She has directed a wide array of clinics involving prisoners' rights, domestic violence against women and children, HIV, homelessness, police brutality, and international human rights. Her scholarship focuses on 3 primary areas: legal education, women's rights, and evidence. Dean Aiken, thank you for being here. We're so glad and grateful for moderating this panel. Thank you and welcome.
Thank you, Kenneth, and thank all of you for hanging in there for this last panel. We have some wonderful people who are joining us and who can give us a lot of insight into character. I am pleased to introduce the members of the panel. Dan Bryant is here. He is the Senior Vice President of Global Public Policy and Government Affairs at Walmart. We also have 2 deans besides me, Angela Awachi-Willig, who is Dean and Professor of Law at Boston University School of Law. Angela I've known for years and is well known for her work in civil rights, racial and gender inequality. She's now playing a really substantial role in legal education and inspiring us all with the work she's done in critical race theory, employment discrimination, and family law. So I'm looking forward to hearing from her. Also a friend is Vincent Rougeau, who is currently the Dean of Boston College Law School. He will be the president of the College of the Holy Cross soon. He also is going to be the president of the Association of American Law Schools. This is a man who has been leading for a very long time and has made a huge impact on legal education and education generally. He was the inaugural director of the Boston College Forum on Racial Justice in America. I am delighted that this group is here. This is a unique group of people. They all have platforms from which they can speak to character and actually have obligations to demonstrate character and to promote actions consistent with character in each of their areas. Character, we've been talking about character a lot, obviously, these last few days. And to stop the close with law makes a lot of sense. We pay a lot of attention to character and fitness and are very intentional about it. Unfortunately, we have lost Deborah Rohde, who was probably the premier scholar in this area. And she helped us see that we were not doing our jobs in ensuring character in the people that we train in law schools. And now we've heard from Debbie McConnell, who in fact has pointed out to us that this embrace of character perhaps has some dark sides, has implicit bias built in, and that perhaps we need to be a little more intentional about what we mean by character and how we know when people are operating from character. So I think we are really in a great position to learn more, and I would love to get started. I think what I'd like to start with is the question, why is character important to lawyers? I mean, there's a lot of issues here. So Dan, why don't you start with why is character important to lawyers?
Well, thank you, Dean Aiken. And let me just say to Kenneth and Michael and Molly and this extraordinary team, what a treat, what a privilege it is to be joining you today. I must say, a lawyer of my vintage and background, it's intimidating to be on a panel with not one, not two, but three deans, count them, three. So what a privilege to be with these leaders in the legal profession. And I'm looking forward to hearing their comments and insights today. So great question, Dean. It's a useful grounding place for us to start. I think it's useful to note that the law, the legal profession is profoundly connected with ethical and moral considerations. A lawyer's work affects people's lives, liberties, reputations. It often involves the proper exercise of not insubstantial governmental power. And routinely, the work of a lawyer requires judgment, discernment. It often involves balancing equities and objectives that at some level are in tension. So it quickly invites a level of wisdom in the practical outworkings of the profession. It's useful, of course, to note that the very idea, the premise of the legal system in some basic ways is to be getting at the truth. So truth should be a major consideration for those licensed to uphold it and operate within it. It's not fitting at all for us to demand that those that get pulled into the system themselves be truth tellers, and yet those of us charged with upholding it and administering it don't have an equal, if not much greater, commitment to be truth tellers. We note that we take oaths in our profession. Not all professions do. We do as members of our profession. And the oath is a crucial part of the sort of truth-telling obligations that permeate our system. And I would also just note that our profession enjoys a license to operate and to self-govern that is itself a grant from society, as it were. We get this freedom to self-regulate in exchange for doing it well, which includes doing it ethically and bringing value to society. So when we think of the rich values that are part of our legal heritage in terms of protecting individual rights, protections even majorities can't take away from the minority, the presumption of innocence, the application of due process, these principles need to be made real day to day. They need to be animated. They don't exist in the final analysis on the pages of a book. They exist in an operation that affects real people. And to get these values right, we have to embody them as lawyers with our callings in the legal profession. We make them real or less real to the degree that they are truly being evident in the way we conduct ourselves as lawyers. So I'll leave it there, Dean Aiken, but thank you for the question. You might need to.
Angela,
No,
do
sure.
you have some things to add about why character is important to lawyers?
Well, I first want to echo what Vice President Bryan started with, and extend my thanks to you, Dean Aiken, and to everyone else who organized, to Kenneth and Molly and Michael, everyone. It's an honor to be a part of this panel. I feel like the person who doesn't quite belong on the panel, but I'm delighted to be here. And the other thing I wanted to say is I also wanted to say that the loss of Deborah Rohde is a tremendous loss, and that she exhibited so many of the virtues that I think that we want to see in our profession. Everything, just for, commitment to justice, to, to respect for the law, honesty, fairness, everything was, she had impeccable character. It's a tremendous loss for our profession in general, and she will be sorely missed. I thought that Vice President Bryan gave an incredibly thorough answer, and so I don't have much to add, except to say that I think the only thing I have to add basically is to say that I think that, one reason why character is so important in our profession is that so often lawyers are in the work that we do, we're caught in the midst of making really, really difficult decisions under difficult circumstances. And when you're in those circumstances, you really have to know what are the principles, what are the values that are guiding you under those circumstances. And those have to be really established and set and sort of just completely embedded within you and leading your actions. And so that's why it's really important, is that it has to be really established and developed. Character must be established and developed when you find yourselves in those moments when those decisions are difficult.
Vincent?
Well, I'll add my thanks to, as everyone else has done. So thank you for having me, and it's great to be here. This is a wonderful, wonderful event. I'm really happy to be a part of it. So I won't add a whole lot, but I thought of two things maybe that can sort of bring together everything that's been said. I think character is important to lawyers because character is important to people, and people need to have their characters developed as they go through their educations, as they enter into whatever they choose to do. And one of the reasons it's important is because how does a community function, particularly a community that is diverse and a community that has, where people have often conflicting desires and needs, without some sort of guiding norms, some sort of guiding principles to help us balance those things, particularly when we are faced with difficult choices. And I guess that's the second thing I wanted to focus on, and that's the idea of these difficult choices for lawyers, because lawyers are given extraordinary power in the society in which we live. In a democracy, lawyers really are the gatekeepers of so many of the things we hold dear. And if they lack the character, if they lack the discipline, if they lack the habits of mind that allow them to put the needs of others before their own, that allow them to understand what is at risk in the decisions that they make, if they make poor ones, we are all in trouble. So, I think for our profession in particular, and that's the other thing to remember, right? This is a profession. It's not just a job. And the people who choose to be a part of it have broader responsibilities beyond themselves. So a highly developed character is an essential part of recognizing the weight of the responsibilities that rests on the shoulders of those who choose to enter this profession, but also, the power that we're given because we're a part of it.
So could you describe, Vincent, what the primary influences were on your development of character? What has made that so prominent in who you are?
Well, I mean, for me, it's, clearly my family was, my parents and their parents were huge influences on me. Their character, I think, was formed in their communities primarily through faith institutions, but also through other community activities that were other focused. So both of my parents were very active in the civil rights movement, and often were putting themselves in situations where their personal desires and needs were going to be compromised in their efforts to do things for others. And so for me, that was a huge and a very important example as I went through my own life, in terms of thinking about, the balance that is often necessary between, sort of individual desires and the needs of others and the needs of communities, or the needs of people who are perhaps in a position of weakness relative to your own, and who need to be able to rely on people who have skills and strengths to, offer them the opportunity to live in a just society. So for me, that was really important. My family, my faith, and it provided a really important sense of balance, because it's very easy to fall into the trap, I think, of just being very self-focused and doing things because they make you feel good. They're giving you a lot of accolades, and they're allowing you to gain lots of things for yourself, which isn't all bad. But we all know that when it's left unchecked, very, very damaging things can happen. So, those would be, for me, I think, the key influences.
How about you, Dan? What has influenced your development as a person of character?
I would echo Dean's comments and start with my parents, both teachers, people of modest financial means, but who were hugely wealthy in ways that matter most: faith, family, community, friendships, faithful, honorable people, diligent, making themselves available to people in need, generous with what they had. I once literally saw my father give the coat off his back to another. I would also say that I feel very fortunate to have had a kind of composite of exemplars over the years. So as a youngster, I thought, what would my dad do or say? And what would this other gentleman in my life do or say? As I have moved through the chapters and seasons of life, I have had extraordinary models, extraordinary servant leaders in my life that have brought remarkable strengths to what they do and how they do it. And I have over time been fortunate to really take from them and form this composite, sort of, as it were, an idealized exemplar that I refer to it all the time. I do remember once commenting to a senior legislative lawyer on Capitol Hill, who was my boss at the time. I said, be really careful how you're living, because I have decided to make myself very vulnerable to your influence. And we had that kind of relationship where I knew that the best thing I could do, young whippersnapper that I was to eat every scrap off the table that I could from the way that person of remarkable character conducted himself in the context of very challenging circumstances. The other thing I would say, conversely, is I've learned a lot from bad examples. I think there's a real blessing in bad leaders and bad teachers. You can learn an awfully lot that's invaluable. And the kissing cousin of that insight, of course, is you can learn a lot from your mistakes. And I have had a treasure trove of opportunities to learn from my mistakes.
Thank you. Angela, how about you? Was this your family, or were there other things too?
Yeah, primarily I would say primarily my mother, especially my mother, my family, my mother. I mean, I grew up, my family is, I grew up in an immigrant family. I was raised by a single mother who often didn't have much more than her faith herself, but was always helping others. And so just watching her example, and her commitment to helping, other people. I think I also grew up hearing a lot about and knowing a lot about civil rights leaders. And so that was also a major example for me, for everybody from Barbara Jordan to Martin Luther King to Fannie Lou Hamer. Those were models for me as well, in terms of character. Teachers who, as somebody who certainly benefited from teachers who recognized whatever talents I had and made sure that they were nurturing it and guiding me. And I was certainly someone who I was not from a privileged background, so somebody who needed that guidance and help. And so I also saw and benefited and saw the ways in which people were reaching back and helping others who needed it. And so I certainly grew up with an understanding that I needed to pay it forward. And you're often told that, and I was often told that in church repeatedly, and as well, that I had to pay it forward. And so those were the things that helped me to develop my character. And at every stage, just like everyone else had said, there have been people who've been models, right? Even as a dean, there are deans who are models for me, including both of you on this panel. And so that's where I learned.
So given how important character is, and you're talking about your families, but you're also talking about people who've been important to you as role models. Obviously, each of you have a universe in which you get to control a little bit about what you project about character, and what you value. As deans overseeing a law school, and Dan, a huge organization in which you're playing a role in shaping how, global policy. So talk to me about, what are you doing in your respective institutions to try to focus in on character and build character in the people you influence? Let's see. Angela, why don't you start?
Always, I'm always trying to ask the right questions and lead by example. So ask the right questions about what are the things that we, in terms of fairness and equity, for example, and justice, right? So what are the things that we're doing that might not be so just in the ways that we run our law school, that might be invisible, right, to us, right? So for example, what are the ways in which we think about opportunities, something like clerkships? I remember very much for clerkships and how do people get clerkships? One of them is that you have to pay for your own travel, versus the way in which you get firm jobs, and which is a firm pays for you to travel out there. They wine and dine you, right? If you go for a clerkship, you have to pay for that. You have to fly out. You have to do all those things. And what that means is that some people who don't have access to those resources can't have to take themselves out of the running, or they have to limit their opportunities in those ways. So really stepping back and thinking about various questions, whether it's something like that, right? Whether it's about so creating resources that enable people who may not have access to equitable opportunities so they can take advantage of those kinds of things. Really having broad discussions about issues of climate, right, in our school. That's a big major thing that we're doing here. So everything from training our faculty and having those discussions as a faculty about the ways in which we have respect for everyone in our community, in the classroom, to the ways in which we ensure that everybody has equitable access to the same education in and outside of the classroom. Are we creating a climate in which everybody feels welcomed and everybody feels included, right? Those kinds of things are really, really core questions. I think those very much have to do with character as well. So it's not just simply having those conversations, but also providing the training, providing the tools. So we not only do that with the faculty, but also do that with the students. And so it's not only providing those educational tools, but also relieving the burden. So one thing that we just started having a class also on a voluntary basis on interrogating privilege, right? So how do we take the burden off of, for example, marginalized students from doing the education that they have to do on a regular basis in order to kind of try to create the environment that they want to be in at the school? So these are like not easy things to do, but really beginning to think about what are the things that continue to make the environment not so equal for everyone or not so fair for everyone, and how do we begin to slowly unravel that and and undo it. And it's a broad range of tactics that we're doing to do that. So some of it's economic, but some of it is also related to climate and trying to educate and undo in that way.
It's so interesting. You're starting in your own home, and your choices that you're making as a dean are demonstrating the importance of asking those questions and starting there, and educating people that probably hadn't thought about those things until you brought them to the table. It's very interesting. Vincent,
I can also talk about outside service too, but I guess other people could talk.
Well, no, we'll have a chance. We'll have a chance. I just think it's very interesting that that's how you start, by demonstrating an attention to creating an environment in which everyone flourishes, and you're also signaling your own character. And so, Vincent, what you're a dean too. How are you shaping character, either in your own home or in your education of the students?
Well, I think Angela spoke really well to the issue of creating kind of a justice-oriented environment in your in the place where you are a leader, be it a law school or a corporation, and that goes to trying to understand what people need and giving them what they need to flourish and thrive. And it's not always the same for everyone. And so, recognizing that policies and procedures that you develop often need to be scrutinized and revised to really understand more deeply the needs of the people that are working with you, for you. From a simple thing, for instance, how we go through in academia, through tenure and promotion, and given what's happened with COVID, how that falls disproportionately on the negative aspects of COVID fall disproportionately on some versus others. And that could be, parents with young children, or it could be, people who have elder care responsibilities. So recognizing that a lot of the things that we have to supervise and manage cannot be done if we're just going to strictly adhere to some notion of, well, these are the rules. But I think the other piece of this for me is, what do I embody in terms of the virtues or the kinds of character traits that I think I should be exemplifying? And, I think of things like prudence and, temperance, and when I say temperance, not in the terms of, not drinking too much at a party, but, temperance in recognizing that I have a tremendous amount of power as a dean, and I need to think carefully about how I wield it and what I, do in terms of how I exercise authority, in terms of how I exercise, mercy sometimes, how I make decisions that affect faculty or students. And, I also think that I have to think a lot about, fortitude, being, a person who recognizes and exemplifies that, there are times when we really have to take on a lot, and, and we are trying to accomplish things as an institution or as an organization. And if I'm going to ask a lot of people, I need to also demonstrate that I'm willing to do a lot myself. So, I mean, there are these constant things that as a leader, I think you have to think about, what is it that I expect from people who are working with me? And what do I expect of myself? And how can I demonstrate, the things I hope to see in others through my own actions? But it all at the end, I think, is done in the context of trying to create an environment where justice is at the center, where fairness is at the center, where, people are really made to fully feel and believe that they matter and that they're valued. And so all of the things we're talking about, I think in the end of the day, go to that work. And, be it our students, our staff, faculty, and in the context in which we work. And, keeping that front and center is really, really important.
So Dan, how does this translate into the business world where you are?
I really appreciate the comments of both of the deans, and playing off of couple of their insights. I've been fortunate to be able to be involved with teams and to lead a variety of teams of lawyers and professionals, both in government and in business. And invariably, I find myself in the very happy circumstance of working with people who are smarter than me and have deeper expertise than me on every issue that we're dealing with. And so to the wise comments of the dean just now, in the context of teams where there is such talent and expertise, I have learned over time the value of knowing my limitations and helping to encourage a sensibility broadly throughout the team where we are all comfortable with the reality of our limitations and the areas of strength of others with whom we work. I would say that I also have found it increasingly to be at the core of my responsibility as a team leader to be creating a culture that brings out the best in everyone, that is thoughtfully inclusive. And it is absolutely about respecting the dignity of each person on the team, as the dean just noted. I would, with my current client, one of the things that I wanted to be sure of before I came in-house and joined the client almost 6 years ago now, is that there really was a true ethic of humility, that humility was real, such that this would be a learning organization that would be thoughtfully self-critical, would have the humility to adapt and to grow and to change. I'm very thankful to have seen that to be very much the case. A word about humility, just since it's just us close friends talking amongst ourselves here, I would say that for a large part of my life and my career, I was genuinely afraid to really embrace humility, to actually, I think, genuinely want it. I was afraid that if I opened the door a little bit to humility, that the door might be blown off its hinges and there might be a truckload of humiliation that would land on me. But I have come to believe over time that humility is almost a superpower. And when you see it exhibited, when you see it being practiced and being realized throughout a team, it's remarkable how it allows a team leader to serve the team by getting out of the way. It allows true listening. I think it's essential to actually empowering team members within an organization and to bringing out its best. So I would offer those sort of teamsmanship related virtues as being invaluable. I mean, if the Lone Ranger lawyer was ever the paradigm, and I'm not sure it really was, I think it categorically is not the paradigm now and moving forward. Given the complexity of issues, the velocity of issues, we have to be bringing the best of multiple professionals and perspectives to bear in order to be solving these issues and really building value. And I think that means lawyers really have to be more and more oriented toward these skills of doing team in this higher, better way.
Thank you. So what we've been hearing from our speakers is that we need to be a little more intentional about thinking about how we train our lawyers or our teams to exercise, to be people of integrity, to have character, and to be aware of how their character affects other people. What are you doing programmatically, for example, and some intentional things that you're doing in your schools that help move that forward, beyond sort of making sure that you've got a just environment and a collaborative environment, but more outward looking? Are you doing any of that, Vince?
Well, we do it in a lot of ways, but I want to focus on something that I think has been really critical. At least it's come to me as over the last decade in this work as being critically important. And it builds off a lot of what we've been talking about. And that's in the ways that we train lawyers, we have to think a lot more at a level of complexity that we have not in the past. So what I mean there is so much of what we did in law school was designed to reward people who were particularly good at digesting what they heard in the Socratic lecture classroom and regurgitating it in a certain kind of way on an essay exam. And those people were the winners. And what we've done then is like over-exercise one muscle that a lawyer uses. And so those people who have like the hyper-extended ability to do that well have become leaders in the profession. And we've seen good things that have come out of that, but we've also seen a lot of bad things that have come out of that. And that's the Lone Ranger lawyer, I think, in a sense. These are people who did not feel that they needed to cooperate and work in groups and learn from others. These are people who were rewarded by being very focused on their own accomplishments, their own ability to learn and to succeed. So one of the things I think we've done in law school that's been a good thing across the legal academy is we started to focus on other skills, experiential learning, for example, group-oriented tasks, externships, things that put people out and into the profession and help them to develop other skills. And so I think the more we can do of that, the better. What we haven't done, that I think we need to do more of, is then we need to think of how to reward people who excel at some of these other skills. Because if we're not rewarding them, if we're not demonstrating that those skills are important and valuable in law school, students will understand that, to get the jobs that they want, they really don't need to spend a whole lot of time on those things. And so that's where it moves into the profession. The profession also needs to start thinking more creatively and more complexly about, the kinds of skills that they need. So if you want people in teams, how do you demonstrate that when you're hiring people? Do you reward the people who've demonstrated that they work well in teams with the job? Or do you reward the person who demonstrates that they got A's on essay exams? We have work to do, I think, to really connect the kind of development in character and skills and other ways to the reward system in our profession, so that the people who are the leaders in the profession are actually embodying this complex, set of moral traits, character traits, as well as skills. Because I think people who have different kinds of skills also are the kinds of people who, spend time developing their character, because they recognize that, there are lots of different ways that people excel and succeed in our profession. So that's something that for me, I think is really important as we look forward in legal education, that we need to continue to do, but we also need the partnership of people in practice and in the profession to help us do that well.
And Holy Cross is lucky, because those same values are likely to transfer right into the college. So that's great. Angela, you were nodding and you wanted to add earlier sort of more outside looking things. Can you tell us a little bit about what you're doing or what you're planning to do?
No, I completely agree with everything that Dean Rougeau said, and President Rougeau said, is what I should say. And so I would think that there are also, I guess, traditional things, and I'll talk about a couple of other things as well. But so experiential, obviously, everything we're doing with experiential learning, externships, clinics, all those things, certainly. But we do some additional things as well. For example, making sure that people are engaged in regular sort of public interest or pro bono work, whether it is a Citizens Day where they're helping people who are seeking citizenship, making sure that they're getting through that process, or spring break pro bono trips, things of that nature. We always want to sponsor those things. And there are a variety of things that we do through our career development office, and including also panels where we have alums who come back and talk about some of these issues, right, of character and development with our students. I think a really important thing that we also try to do is really, really work with our students as co-leaders and engage them with decision-making responsibility on important issues in our school. So I'll give you a couple of examples. One of them, we did a big conference on rethinking the 1L curriculum, in particular, rethinking the 1L curriculum as it relates to racial disparities and subordination, basically in the curriculum, and the invisibility of issues of race, or the sort of the hesitancy for some faculty to bring up those issues in there. And we very much included our students in that planning process, but even more so, we included them on the panels with experts, and they did a phenomenal job, but because they are experts as people who are consumers of that knowledge in the classroom. And so including them as well, right, that helps to, of course, develop a variety of character related traits as well. Engaging them and thinking about, so I think some of the work that we've done in terms of just having a broader conversation about climate issues has really pushed some of our leaders to come to us and say, we want to talk about how do we revamp our processes to be more inclusive. So everything our law review leaders came to us to want to talk about and work with the administration on revamping their processes to try to make it more inclusive as well. And I know that BC has done a lot of work in that regard as well. We've also tried to sort of experiment with our classes so that we're also doing a little bit more of the experiential work in our regular classes. So we've started to do more, tying more seminars and externships together, right? So really not just having the sort of the separate world of the theoretical doctrinal classes and the experiential classes, but having seminars that have an externship component. So people are learning this theoretical doctrinal component of the class as well, but they're also part of that class is they also have an externship component where they're going out and they're applying the theory they're learning in that particular class and bringing it back into the classroom. And so that they're grappling with these issues in the class in the middle of the semester as well, right? So there's an applied aspect to those also very theoretical and doctrinal courses. So those are some of the things that we've been experimenting with and trying, and I think it's worked out. But including students in more and more decision making, whether it's our appointments committee that they have a vote on, or whether it's the diversity, inclusion, and equity committee that they have a vote on, but really just including them more as decision makers. I can think about my own experiences. That was really crucial to me in terms of the kinds of skills and the character that I was building when I was a student. And so we're trying to replicate that as much as possible.
So Dan, that co-leadership that Angela's talking about sounds a lot like your humility, your commitment to humility, and your commitment to teams. Are you making intentional choices of programmatic nature or any of those kinds of things in the work you're doing of counsel and in the general counsel's office with what you're doing as a vice president?
So there's a lot of collaboration between my team, the Global Policy Government Affairs Group, and the legal team, as we're seeing questions and issues of law and policy converge and interact in a variety of ways. So we do team up with our legal eagles routinely on issues. I would say that we are also very much focused on what it means to be a high-performing team that leverages the legal skills within my client more broadly. And we're really thinking through questions of people, culture, mission, vision, strategy, priorities, and how all of that at the end of the day gets carried along by a commitment, not just to what we do, but how we do it. And so we spend a lot of time as a team at every level talking through not just outcomes, but means that we are willing to employ in order to go after outcomes. And here I would emphatically underscore my experience of how much this question of tone at the top matters. It's obviously not enough, but for us as leaders of institutions, these extraordinary deans, you, Dean Aiken, for us as team leaders in a variety of ways, leadership that explicitly calls out the premium on ethics and character is indispensable. Saying that integrity matters, meaning it, modeling it, rewarding it, commending it, having it guide the way we build out our staff, our teams, our firms. I don't think that we are doing nearly enough to push back against the volume of bad stories that are out there in the public domain regarding the legal profession. There are a lot of good stories, and we need to be thinking about how we bring them in and use them thoughtfully to inspire. That's not hokey. That's what cultures that are committed to elevating do. We hold up those who are worthy of honor. We hold up those stories of exemplars, and we celebrate them. If I could give just one small example, when I was with a prior large global company, the general counsel of the company, a gentleman named Larry Thompson. Larry has had a storied career. He had been a United States attorney 1,000 years ago. He'd been an independent counsel. He had served as deputy attorney general and now as general counsel at PepsiCo up in New York. Well, one day he received an anonymous package from a disgruntled employee of a competitor based in Atlanta, Georgia. And it contained, and this is factually accurate, in that package were trade secrets, including things that looked like a formula. And so Larry glanced at it, got a sense of what was contained in it quickly enough to know that he did not want to review it any further. He closed it back up. And then what did Larry Thompson, the general counsel of PepsiCo, do? What's the right thing to do at that moment? What Larry chose to do was to call the general counsel of his competitor. He directed the head of global security of PepsiCo to fly that package down to Atlanta and to turn it over to his counterpart at the FBI Atlanta field office, so that there would be that level of third-party visibility into what was going on. He did it without conferring with his CEO, that is Larry Thompson, general counsel at PepsiCo, took that action without conferring with his CEO, without conferring with anyone else in the company. Subsequently, the CEO of the competitor called up the CEO of PepsiCo with effusive appreciation, praise for how things had unfolded. We need to be celebrating those stories, and there are lots of them. They need to be seen as normative. That's the kind of profession we inhabit. That's the kind of standard that needs to characterize our performance day to day. So we're trying to bring those standards, those ethical commitments, and frankly, that kind of judgment where Larry didn't have to really deliberate long and hard about, what do I do with this? Is there a kind of advantage that can be obtained here? And yet I'll do the right thing, kind of. Larry didn't have to overthink it because of all of the decisions, all of the life experience that had preceded that moment, and because of tone at the top and the culture that he had been helping to establish for a 6-year period prior to that point as general counsel of the company.
Wow, that's quite a story and quite an example. It feels like recently we've been getting a lot more bad examples than we have been getting good examples. And in fact, some people say that's why more people are applying to law school, is that they want to make a difference. They want to make some change happen. What do you think, given our circumstances now, the biggest challenge that you face in dealing with sort of coming back together and getting people to focus on the importance of character? What's your biggest challenge right now when you think about it, in light of what we've just gone through? Angela, can you start?
I think I think one of the biggest challenges is that we're so divided. It is that we are so divided, and we have in some ways stopped listening to each other. And so You know, one of the things is that I've been going around and meeting with each of the small sections of the small lawyering program sections of the first years and talking about everybody's responsibility in creating a community where people can listen to each other and say what they think without being canceled. But there really is more of a, you know, I think that people are more fearful of saying what they believe for fear of, you know, feeling like people won't listen to them or people will cancel them. I think that there's great division in our society, which makes it really quite difficult. I think another hurdle is that people are also coming to law school with this huge sense, in the same way that I did, of what the law can accomplish, right? And not recognizing all of the flaws in the law, and seeing the law as being I don't want to say much more pure, which I'm not sure what the right word is, but much more pure, also what I'll use, the purer than it is. And I think the law in itself, like any other tool, is flawed, right? It's narrow in many ways. It's, you know, it's an important tool. It can be a really effective tool, but there are all kinds of flaws in it. And I think that we have to talk more openly about the flaws in it as well. And I think that's another obstacle, is that if we aren't honest about it, then I think it's also really easy for students who have come here, particularly with their eyes set on doing justice, to become jaded really easily and to feel like they can't do the work that they wanted to do when they came to law school.
Wow, I hadn't thought about that. That's really interesting. That energy that's coming here has got to have some grounding. Dan, how about you? What do you see as the biggest challenge?
I think that the dean's comments were so very apt. I might just add that my concern continues to grow, that too often there is a perception that is permitted to be real in the practice of law, that it's okay to cut corners in order to win. Obviously, we're not teaching that, and yet too often in the actual practice of law itself, in the marketplace, I see that perception coming to life, that it's okay to cut corners to win. So I'm concerned that we as leaders, those of us who have a few more years under our belt, that we not be impeded by the fear of being perceived to be a blue nose or a moralizer if we talk up ethics too much. So I think we have to continue to walk the walk and talk the talk. I do think that it's challenging to find your voice as a lawyer leader and to figure out the right way to authentically affirm ethics embedded in all we do. And I don't think there's one right way to do that. I think each lawyer leader has to draw on what they own already in terms of their convictions and their experiences, and to speak authentically from that. I love the old saying, if something's worth doing, it's worth doing poorly. Now, that's not to say we should compromise and accept something that is less than excellent. But it is to say, when we are trying to do hard things as lawyer leaders, in the way that we are moving a culture forward and trying to lift a culture, that we can't allow the fact that we might get it not perfect to be the occasion for our not taking that action and being committed to that action, and then doing it again and again until we begin to build that muscle and get better at it.
Vincent, how about you?
Well, when I think of this, I think of a couple of things. We talked a little bit about what virtues lawyers need to be the kinds of lawyers we hope that they will be, and to create the kind of profession we hope to see. But we also have to think about, I suppose, the vices that lawyers are susceptible to. And it goes to the issue of division, and it goes to the issue of the negative ways lawyers are often perceived. And I think of two, pride and greed. I think pride being in particular a problem, because I just think so many people in our profession become so enamored with their power and with their abilities to make things happen or not happen, that they lose sight of the context in which they're operating and the responsibilities they have beyond themselves or perhaps their client. So that leads to often these this winner-take-all mentality, which you saw in some of the issues we were facing as a nation, where lawyers were getting involved in actions that clearly were undermining our democracy, our courts, our justice system. And you saw a profession that seemed almost incapable of calling out what it knew was wrong, right? The use of process in a way that clearly was designed to undermine the ability of the system to function properly, the ability of individuals within the system to exercise their rights. And those should not have been difficult things to see, but for whatever reason, because pride and this notion that you win at any costs, it became clear that, that discussion wasn't going to happen. And then it also, I think, goes to greed. I mean, I think people become, they're greedy. They want money, they want power, they want status. And it's hard to talk about that, but let's just be honest. Many people in our profession are obsessed with status, obsessed with their ability to make a lot of money doing what we do, and take cases because they want the fees, they want the accolades, they want to win. So recognizing that those are dangers that some members of our profession suffer from, and recognizing the harm it does to the common good, I think we have to be, in our conversations about character, we have to be looking at both sides of the coin, right? We have to say, this is what we hope you will become, this is what we're afraid you might be. And we don't want you to be this person that we fear, and this is why. I mean, this is what could happen if more lawyers continue to behave in that way. And this is what will happen if more lawyers behave in the way that the general counsel at PepsiCo behaved. And that's the world we hopefully want to move into and to support. So I think sometimes, and Deborah Rohde, I think, was brilliant in her work in recognizing this and calling it out. We say we're a self-policing profession, but we don't do a very good job at it. Why not? What's preventing us from doing that? What are we afraid of? What are we resisting? And if we can look at that more honestly, I think we can start healing some of the division within our own profession, and certainly, hopefully, within our own country.
Well, those are hopeful moments, and they're describing big challenges. I think before we close, I do want to hear from each of you. What do you hope for? What are you excited about that you think may be possible as you move forward? And in educating and moving toward justice and character. So Vince, let's start with you, because you mentioned hopeful.
Well, I have been so inspired by the young people entering this profession, the young people I've been able to teach, and who are so excited about what the law can do and what it can be, particularly in recent years, where there have been so many negative examples of the law in action or inaction. I want to believe, and I do believe, that our profession can and will, be an engine of creating the kind of democracy we want to have. If we can create a more diverse profession, if we can create the kinds of lawyers who are really focused on character and are focused on the responsibilities that they have to the common good and to our democracy and to our lives as a nation, as a community, and if we allow our profession to represent the community as it actually is, in all of its diversity and complexity, we will become, a better place. This nation will do the work it needs to do to really be a just and fair society. And I know that this profession can do that, can be a driver in that. I mean, obviously it will be working with many, many others, but we play a critical role in the development of a just and fair democracy. And we have to continue to work hard to make sure that the people we educate believe in that and will work for that. And I know that we can do it, and I think we will.
Dan, how about you? What do you hope for? What are you excited about?
I see a great opportunity for the legal profession to play an extraordinary role related to the crisis of trust. So I think the crisis of trust is real, it's measurable. The diminishment of confidence and trust in institutions broadly, almost without exception, perhaps since the 70s, the military would be the one institution that would be the exception of increased trust, but broadly otherwise, this reduced trust that people have across the sectors of our common life and across institutions. I think when we think about how lawyers over-index as leaders in public life and the private sector, and how we are part of a profession that involves trust throughout what we do, as we've noted, and indeed a profession that benefits from the public trust of being self-governing. I think that between law schools, state bar associations, and law firms, legal departments within companies, government agencies that retain lawyers, there can be a conspiracy for the good, as the president alluded to, and the dean as well, where the opportunity for lawyers to play a role in this recovery of trust, and trust broadly, and trust specifically in institutions, I think is hard to overstate. So lawyering, good or bad, ethical or unethical, ends up being part of the lubrication that helps our institutions work. We are not going to have a meaningful recovery of trust in our society if we don't have institutions that are individually recovering and recapturing missional integrity, where they are really able to be clear about their missions and to go after them in the right ways as these formative communities that are forming what, among other things, character and judgment. And I think the role for lawyers within that recovery of institutional integrity is enormous. Our institutions need thoughtful lawyers to be involved. Lawyers are involved. I hope there is a recovery of a high view of the way we engage institutions and help them do better and succeed within the legal profession that will contribute to this turnaround as it relates to trust.
Thank you. So I'm going to give you the last word, Angela. How about you? What are you hopeful or excited about with regard to lawyers and their role?
Yeah, so I think it's a combination of two things. I'm excited about this generation in many ways, and I think it's just it's a generation that expects more than I think than any other generation is expected in terms of fairness and justice and inclusivity. And I like that they are demanding the world that we promised them and that we said that exists. And so I'm very much like that, and I'm hopeful. I think in part because some of the questions that Deborah Rohde raised in her paper that I think can allow our profession to enable that more. And I think there are questions that she raised about the ways in which we might be preventing people from entering the profession or even applying to law school, the very people who might work to create some of those changes, right, in our society and in our profession. And so I think I'm excited that work is raising those questions in a way that might change those entry points, both in law schools. I feel like I learned a lot from that work that now I'm like, okay, now I need to want to go back and look and think about how are we handling those issues, right? And I hope other people are as well. I hope other state bars are rethinking those questions as well. And I hope different schools, or thinking about how do you recruit people who have particular backgrounds. I mean, I think that thinking about all those questions is going to help us create a different legal profession that might create precisely the kind of change that we want to see. And so I'm excited about those possibilities.
That's great. So I'm inspired. I'm really inspired by this conversation. It feels hopeful and clear. And I've got such good ideas myself. So I want to thank you so much, Dean Onwuachi-Willig, President Rougeau, and Vice President Bryant. You guys are amazing. And I feel like I've really benefited, and I'm sure that the people who are listening have benefited as well. Thank you so much for your time, your energy, and your thoughtfulness. It really was inspiring. I also want to thank Kenneth Townsend and Michael Lamb and Mary Cosby, because you've put this all together and you gave this opportunity to us, and it was quite meaningful, and I'm very proud to have been a part of it. So I turn this over to Kenneth at this time.
Thank you, Dean Aiken, and thank you, panel. I mean, I was just steadily taking down some notes. This was so much fun for me. And I'm teaching a leadership and character in the law course and a character professions course. And I think I have some new content for my students, some of whom are I hope, watching this. At least they're supposed to be. This is really, really exciting stuff. I would try to recap it, but there's too much good stuff to try to recap, I think. So I'm going to leave it with you all, giving us the more or less final substantive word. But I do thank you once again, and to thank everyone who has helped make this possible, including the people on our team here at Wake Forest, all of our conference partners and funders, all of our panelists and moderators and speakers, everyone who has tuned in. Unfortunately, this is the end of our conference. This is the end of our 3-day conference, but what a great way to wrap it up. So even though this is the end, I'm happy to report that sometime in the next few days, it is our hope to have all of the recordings of the conference sessions available on our website, leadershipandcharacter.wfu.edu. So stay tuned, keep a lookout for that. Also, keep an eye on not only our website, but Oxford Character Project, our teammate in all of this. And follow us on social media if you're not already. We look forward to keeping you updated on the various things that we have going on. Again, thank you so much, Jane, panelists, for wrapping us up in such a powerful way. And to everybody watching at home or wherever you might be, thank you for being a part of this. And go forth and lead and live with character and integrity in all you do. Thank you. Have a good night.